Hi Miss Cho, I'm Nabila, your lawyer for today. May I know for what matters do you come today?
I need help with my divorce. We've been married for 10 years. For the past few years, it's been nothing but fight, shouting, and silent treatment.
I understand that it might be hard for you, but can you please tell me more about this?
In our marriage, I am the only one who working, taking care of our kids, paying the bill. He just exists. I'm so exhausted. I don't want this marriage anymore.
It's okay, miss. That must be really hard for you, but don't worry, you are not alone now. We'll go get through this together. So we'll prepare a court order called Decree 9 to formalize this. It's a settlement between you and your husband. But before that, I need you to sign this warrant of act.
But my English is not very good. I can talk, but I cannot read English very well.
Oh, it's okay. It's just a warrant to act. You just need to sign it.
Okay. How about your legal fees?
Our legal fees, we can decide it later. Okay. Okay, thank you.
In the matter of divorce between Puan Cho Mei and Yap Chun Siang, this court hereby grants a decree nisi as agreed by both parties. Rm 200,000 ringgit shall be paid immediately to the petitioner. The remaining 900,000 shall be paid in 60 monthly installments of Rm 15,000 ringgit. Payment are to be deposited into petitioner's bank account on or before the 10th of each month, starting May of 2018.
It's done. The order is official. You will receive the check for 200,000k shortly, and another 900,000k will be paid monthly by installments of 15,000 ringgit for 16 months. Later, you can come to our office and we will give you the check of 200,000 ringgit upfront.
Thank you so much for everything. I'm glad that everything has settled.
Good evening, Ms. Chu.
Good evening.
Please have a seat.
Thank you.
What can I help you with?
I came for collect my 200,000 check from the settlement.
I see. Yes, Ms. Chu, but before we release the check, there is one more thing. This is the second agreement, which is service agreement. We will charge you 6% of the monthly 15,000 ringgit you receive from your husband.
What is this document about? I cannot read English very well, and I don't understand any legal terms in this document. And what do you mean 6% of my money? I thought your payment was 25,000 ringgit based on our first agreement. Why is there a second agreement?
Ms. Chu, we will handle all future matters related to the enforcement order, ensure that he pays on time, and take action if he does not pay. It's okay if you do not understand, just sign it.
No, I don't want to sign this document.
If you don't sign this document, we will not release the check.
You don't understand. I have 2 kids. Their school fees are overdue. The loan house is 3 months behind. I've been borrowing money just to buy groceries. You cannot take my money.
This is the standard procedure, Ms. Chu. We will give you the check if you sign this.
Fine, I will sign this agreement just because I need my money.
Hi, Miss Cho. What can I help you?
Hi, this is Cho Chooi Mei. I'm going to let you know I will engaging a new firm to handle things going forward.
You cannot do this, Miss Cho. May I know what is the reason?
I think I had enough. I appreciate the work done, but I was not comfortable with how they work, and especially the second agreement. I will change into a new firm. Therefore, I want to cancel the second agreement. I think you are overcharging me. Please prepare your final invoice. I will send you check of 10,000 ringgit for the first agreement.
We will accept the check, but we will not consider this as final settlement. We will get back to you later. Thank you. Mr. Aszezy, Miss Cho just called me right now and she said she wants to cancel our service and appoint new lawyer. She does not want to pay the second agreement.
No, we cannot let her change to new lawyer. She had already signed the document. Prepare the document to sue her.
Okay, I'll prepare a document to sue her for not paying our service.
Will do.
Hello
Hello everyone, just now you just saw a video of my firmmates acting about this case. So I will be presenting the background for this case. So this case is about a woman seeking divorce, which is the defendant, initially soughting help from a legal firm, which is the plaintiff, and signed a warrant to act, which we call as the first agreement, although they did not agree on the legal fees at that time. So the woman was illiterate and was not good in English. Her divorce was financed by a consent through a decree nisi order, and subsequently under the order, she was entitled for 1.1 million ringgit from her former husband, with 200,000 ringgit paid immediately and 900,000 paid in monthly installment over the 60 months. So the defendant was charged by the legal firm for 25,000 for work done up to the time the divorce was filed, and she paid 15,000 ringgit towards this fee. And afterward, the defendant entered into a second agreement with the firm's managing partner, and the agreement stated that the firm would deduct 6% from her former husband's monthly installment of 15,000 ringgit over a period of 60 months starting from May 2018 as legal fees, and the firm would ensure her former husband complied with the order and act for her if he defaulted. So the firm has stated that they will not release the 200,000 ringgit check if the defendant refused to sign. Later, the defendant instructed a different legal firm, Messrs Boy and Yi, to take over this matter. This new firm later informed that the original firm that they wanted to cancel the second agreement and requested the final tax invoice for the legal services rendered. Following this, the defendant issued a check for 10,000 ringgit Malaysia as a full and final settlement, which the original firm accepted under the protest. So the plaintiff then sued the defendant to claim the balance payment under the second contract. So that is basically the background of this case. Hello everyone, my name is Syamirah binti Rahuman Sadik, and I'll be presenting on the court's decision in the case of Messrs Albert Ding, Lee and partners against Cho Chooi Mei. So the court began by reaffirming that the relationship between a legal practitioner and their client is fiduciary in nature, and this imposes duties of honesty, negligence and clear communication. So in this case, the plaintiff, which is a law firm, had a duty to act in the best interest of their client, which includes properly briefing her on any further instruction and applicable legal fees. However, the court found that this duty was not fulfilled. The main dispute centered on the second agreement, which the court held to be void, and under section 118 clause 3 of the LPA, the court has ruled that the agreement contained terms that were unfair and unreasonable, and the services under the agreement, such as supervising and updating, were described in a vague and redundant terms. And more importantly, the plaintiff has failed to clearly explain these services to the defendant. So this part of the decision can be seen in paragraph 54 until 57, 60 and 68 of the case. Following more, the court found that the second agreement violated section 112 of the LPA, which prohibit contingent fee by arrangements. By linking legal fees to the successor of the client's financial settlement, the agreement effectively became a contingency agreement, which is something that is strictly prohibited. So the court has referred to the case of Tetuan Syamirah against Akbardin Haji Abdul Qadir and concluded that such agreements go against public policies and professional ethics, and accordingly, the agreement was also declared void under section 24 of the Contract Acts 1950, and this part of the decision can be seen in the case paragraph 55 until 56. So to declare the agreement was void, the court also identified several breaches of fiduciary duty by the plaintiff. So firstly, the plaintiff has breached its duty to act in the client's best interest by failing to explain the second agreement clearly and by allegedly coercing the client into signing it, specifically by withholding a check as a leverage. And second, the plaintiff has breached his duty not to enter into prohibited fee arrangement, as the fees are calculated based on the client's monthly settlement sum, which contravenes section 112 of the LPA. And third, the plaintiff has breached the duty not to overcharge, and the court found that these fees under the second agreement were vague, excessive and unjustified, which is in violation of the requirement under section 94 clause M of the LPA, and that fees must be fair and reasonable. So that is all for the decision of the case. Thank you.
Good day, my name is Magdalene, anak perempuan Pakianathan with the matric number 065539. I'll be presenting on the legal principle of this case. The first one, Rule 16 of the Legal Profession Practice and Etiquette Rules requires an advocate and a solicitor to prioritize their client's interests, justice, and the profession's dignity. even at personal cost, while respecting the tribunal. On the other hand, Rule 35 of the same Act mandates that an advocate and a solicitor must not exploit the client's trust for personal gains and also must maintain a confidentiality even after the professional relationship ends. In this case, a lawyer must clearly explain a contract to a client, ensuring full understanding of the terms, risks, and obligations, and also cannot coerce the client into an agreement. The next, Section 112 of the Legal Profession Act 1976 prohibits an advocate and a solicitor from entering into an agreement where payment is contingent upon the success of a suit or an action. In this case, the court ruled that the second agreement constituted a contingency fee agreement, which violates the public policy and professional ethics. Lawyers are prohibited from charging such fees, meaning they cannot take a percentage like 6% of the money awarded. In the Section 94 of the Legal Profession Act 1976 grants the disciplinary board the authority to strike off or suspend a lawyer for misconduct. Misconduct, as outlined in Section 94 Clause 3, includes an action that are deemed grave impropriety, such as charging grossly excessive fee without a written agreement. In this case, the lawyer excessive fee charged were deemed to be an ethical conduct. Additionally, the plaintiff's refusal to discharge itself was considered morally wrong, thus falling under the misconduct as defined in Section 94 Clause 3, Clause M of the Legal Profession Act 1976.
Assalamualaikum and good day everyone. Now, I'll be talking about the impact of the case Messrs Albert Ding, Lee and partners against Cho Chooi Mei and what it means for the legal profession in Malaysia. First and foremost, this case shows that lawyers must always act honestly and in their client's best interest. In this case, the second agreement has exploited the client's vulnerability and created a conflict of interest. The plaintiff charged a percentage of future payments, which is a form of success fee, and it violates the fiduciary standards. This case teaches us that the core of the legal profession is the fiduciary duty, whereby lawyers owe their clients an obligation to act in good faith with loyalty, integrity, and in their client's best interest. Next, based on this case, the client entered into a second agreement with her lawyer. In that agreement, the lawyer will receive 6% of any future payments the client got from her ex-husband. This is what we call a contingency fee, a fee that depends on the outcome of a case. Lawyers in Malaysia are not allowed to charge such fee. Thus, this case explains to us that contingency fee is a serious ethical misconduct. It is because they can lead lawyers to focus more on winning money than giving fair advice. In addition to that, in this case, the plaintiff had a duty to communicate clearly and make sure the defendant, who was not fluent in English, fully understood the agreement. However, the plaintiff failed to do so and did not ensure the defendant knew what she was agreeing to. Therefore, we can learn that any agreement between lawyer and a client must be clear, fully informed, fair, and made without pressure. Lawyers should always treat their clients with honesty and respect, not use their position to benefit unfairly. Lastly, this case taught us that the Malaysian courts actively make sure lawyers follow ethical rules. Even if no one complains, the court still can cancel unfair agreements. This reminds lawyers that ethical rules are serious and must be followed. In conclusion, this case is a wake-up call for all legal professionals. Ethical obligations are not just formalities, but they are enforceable rules. Lawyers must be honest, fair and responsible, and clients must be protected from being misled or pressured. Let this case be a reminder that the trust placed in a lawyer is a serious responsibility and it must never be abused. Thank you for listening. I hope this case helped all of us reflect on the importance of ethics in the legal profession.